Welcome to Strategic Alignment, ensuring long-term profitability in multi-brand franchising, where three industry leaders delve into the intricacies of multi-unit and multi-brand ownership. Join Jeff Bannon and Greg Sisa, succession planners at the Rawls Group, along with Nate Riordan, founder of West Coast Franchise Law, as they explore a wide range of topics, from franchise approval and crucial nuances to consider before finalizing business agreements, to business structures, exit transition strategies, and estate plans. This series covers it all. In the franchise world, the franchisor is not just a business partner, but also a key player in all your franchise ventures.
Please keep a few things in mind. One of the things we've seen recently is extensions are personal to the owner. And personal to the owner means the person who owns it. So that if in 10 years, the composition of the business changes, that's technically not the owner. Probably not going to get pulled out, but technically, that's an issue. To me, that clause is a non-starter. Don't do the deal, don't do the lease. Don't do a lease where you can't keep the extensions on the terms they're at when you sell the business. If you don't have the ability to transfer the extensions, the extra time on the lease, they're going to get renegotiated when you sell. It's going to affect your cost structure, which will affect the prospective EBITDA, which will change the purchase price. There will be a renegotiation of your purchase price when you go to sell, if you have that term in your leases. If you have it in your leases now is a good time to set about getting it out of your leases. Maybe you can't do it. Maybe you didn't have the help you needed, or maybe you just had to get that particular spot. It is what it is. But if you've got any leverage or anything the landlord wants to talk about, or just maybe the landlord doesn't care anymore. We've asked for that provision to be taken out and just had landlords go, oh, okay, sure. So that's like the first thing. And this is a little bit of soapbox because I keep seeing it more and more and more. And it's got to go. And I mean, the other thing is, it's not just a renegotiation, it takes time. And when you have a transaction you're selling, you want to go as quickly as possible. Time is the enemy. More time, more questions, more change, more expense. And adding a wrinkle like, oh, now we got to renegotiate the lease, just expands the time window. And if you have, the more leases you have that across, the more you risk that issue. Your leases should be coterminous with your franchise agreement, meaning that they should line up. Your franchise agreement and your lease should end on the same day, and then the extensions that you have for the lease should term out so that if the franchise agreement is renewed, you have the same amount of time. That way, if you go to close the store, there's no overhang. You can't have the landlord holding you hostage because you have a franchise agreement that extends past the lease expiration date. You're going to be in default under your franchise agreement if you don't have a place to operate. Conversely, you don't want to run out of franchise agreement and get stuck with a liability on your lease because you couldn't operate a business there anymore. So those are two things that we've absolutely got to have. And the other thing is, and this gets blown by a lot, is if you have a property that is, for the most part, triple net, but picks up some CAM charges, really look at what those CAM charges are. Is it clear? And not just is it clear in the lease, but when you get the CAM invoice every year, are you going to be able to tie what it is that you're supposed to be paying to the invoice? Maybe you request an invoice. Hey, what do the invoices look like when you send us these CAM charges? That's not a weird request. They should just have that. Oh yeah, here's what that looks like. That way you can check if you're actually being charged what you agreed to be charged. And this is not like, people don't get up to stuff necessarily and do this. It just creeps. And all of a sudden it's the third iteration of the owner at the shopping center, and they just do it their way. And someone in your AP gets this thing and they don't question it. And the next thing you know, you're paying $10,000, $12,000, $20,000 more in CAM charges than you should have been. And now when it's time to check, it's kind of hard because it didn't exactly line up. So there's three things off the top of my head. I'll shut up and let you guys add something. I'm sure you guys see this all the time. I'm curious what you think.
Oh, yeah, I think obviously going through those contracts in detail with something like someone like you is worth its weight in gold. I can't tell you how many clients we look at as we start working with them where we're reviewing their contracts and their legal documents that are in place. And you either find yourself in a how do we get out of this situation and prepare the business for to be in this to be able to catch its highest value if we're going to sell, or it's in a position to continue through the next generation if that's our plan. But having this done on the front end precludes a ton of heartburn as you start looking at what the end goal of your franchise is. I think some key components that we look at in terms of succession are, the extensions on the leases are critically important, because if you look at families who have an estate distribution plan that says, I want my operating company to go over here because these kids are involved in the business, and I want the real estate to go over here because they're not, but it's okay. The real estate doesn't require active management. You essentially position the next generation at odds with each other because one is looking at how do I keep the rent low to maximize my EBITDA. The other one's saying, well, I've got this real estate. How do I maximize the revenue I want from it? From a family harmony point of view, what you want to avoid is having any negotiations among family. Negotiations typically end in a win and a loser, win or loser dynamic. And you don't want any family members to walk away from each other saying, I'm the loser. That makes sure that Thanksgiving and Christmas gets pretty difficult going in the future. So the importance of not only from the franchisor perspective of having those extensions for your family's sake, having the ability to preclude any negotiations between them is a huge step to make sure that you position your family and your business to be successful.
I like to see my clients who own real estate have a formal lease agreement, put the real estate in a different entity and have a formal lease agreement with the entity, so that there are things that come up that it's just helpful. And I can see here listed, most of them are scary downside things like, oh, if there's a default over here, we've at least got this, subset over here. And if you want to split the financing between real estate and operations, that's easier to do if you've got the separate entities. So those are reasons to do that, but it's also if you want to sell it. And this gets to succession and who owns what, and who, maybe one branch of the family is going to leave with the real estate, the other one's taking operations. It's just easier if you got it separate. And what I'll get from clients is, well, yeah, but I want the flexibility to adjust my rent. That doesn't have to change. We can just change it. You can do a forbearance, or you could just send yourself an email that you agree. You really have to put on a hat, like it's this entity and this entity, but something that says we're letting you adjust the rent down because the store's closed because of construction, or just whatever it is. So having a formality, I think, benefits us from a right now standpoint, from an accounting standpoint, from an ability to assess what are our covenants and measuring our covenants, having them in separate things. Sometimes it's rare that if we're in a circumstance where an audit's required, we can keep the real estate out of it, but it's not unheard of that it just simplifies our audit by having the real estate separate.
No, I think, I think what you hit on is important there on the separate entities for the real estate. I mean, obviously it's important, I think, for every business owner to understand, like you said, that you can wear two hats in two different entities and completely control what the rent factor is, what the lease agreements are, et cetera, whether or not it's in the operating company or outside the operating company. And I think, from a business structuring standpoint as well, I mean, real estate's going to limited liability companies for a reason, right? It limits the liability. And to have real estate owned in the operating company does not have limited liability there. So, the thing we hear from most clients is, well, the company's, the operating company is where the money was. And so I took the money from the operating company and I bought the real estate. But, the good thing is you can unpack that situation, which we are forced to do quite a bit, and then formalize the documents between the two entities for continuity of lease agreements and future cash flow and rent factors.
This is only one out of our 8-episode series focused on ensuring long-term profitability in multi-brand franchising. Continue listening to the series now or come back for more. Each topic featured may want you to learn something new. Succession planning allows you to create more control over the future you envision by proactively addressing possible, probable, and potential issues impacting your long-term goals. You can create many options at your fingertips. Do you have a question you want to discuss with an expert? Feel free to reach out directly to Jeff, Greg, or Nate at the email addresses listed on the screen. Strategic alignment, ensuring long-term profitability in multi-brand franchising, is a part of the Rawls Group's Advancing Your Business, People, and Legacy Conversation series.